No television courtroom had ever seen arrogance meet its destruction quite so completely and so publicly. Many benches have held me across my career, but what filled that room on this particular day would be answered with something considerably heavier than words. Brenda Marshall, a woman in her early 50s who had spent 6 years systematically terrorizing small business owners through fraudulent lawsuits, occupied the defendant's chair, wearing the particular brand of smug superiority that only develops in someone who has moved through life without ever encountering a real consequence. Her manicured finger extended directly toward me as the words that would ultimately cost her $75,000 and years of her freedom left her mouth with a level of audacity that is genuinely difficult to overstate. "Maybe you should calm your hormones, Judge," she said. The room went silent in a way my gavel has almost never produced on its own. For a television moment, the conditions for virality were present. But I do not practice theater. I practice law. I work with evidence. And when she leveled a sexist, ageist taunt at this bench, she accomplished something she had not intended. She revealed the contempt that powered her entire operation. Brenda did not simply lose a single case. She was not merely embarrassed in front of millions of viewers. What unfolded in the minutes that followed was the dismantling of an enterprise. What I did in the 30 seconds after she spoke was not a spectacle designed for cameras. It was the judicial and investigative exposure of a criminal operation that had extracted $412,000 from vulnerable immigrant business owners, forced closures, and destroyed livelihoods. The legal record assembled in that courtroom set off federal criminal investigations across multiple states. It exposed a detailed playbook of organized extortion operating behind the language of civil rights advocacy, and it began the process of financial restitution for victims who had been bankrupted by carefully orchestrated campaigns of shame and reputational destruction. Let me tell you exactly what I told her, because the facts carried their own weight and the law demanded precision. "You have a playbook," I said, "and I have read it. The pattern does not leave room for misinterpretation. Identify small businesses owned by immigrants who cannot afford to defend themselves in court. Present accommodation demands that would cost thousands of dollars to satisfy. Record the refusal using hidden cameras. File a lawsuit claiming discrimination under federal and state statutes. Launch a coordinated campaign of negative reviews and media pressure. Then offer a settlement for an amount between $8,000 and $15,000, a figure chosen specifically because it sits just below the cost of mounting a defense through trial. That arithmetic is cruelty converted into a revenue model." Brenda had refined the mechanics of it with considerable care. A failed attempt at law school, 8 years spent as a paralegal, and an instinctive grasp of how expensive litigation becomes for those without resources had taught her exactly how fear could be priced and sold. She located physicians willing to sign off on dubious medical claims for payment. She recruited people to play scripted witnesses. She built digital templates for defamatory reviews that could be deployed quickly. She packaged a coaching product that taught others how to replicate the scheme. She retained counsel who drafted complaints in language precisely calibrated to maximize panic in a small business owner with no legal background. The operation was precise, scalable, profitable, and thoroughly industrial in its design. But she had overlooked a fundamental truth. When criminal intent exists, the law accumulates a trail. Patterns leave fingerprints. And one of her intended victims, a woman named Linda Cho, refused to accept the role of anonymous casualty. Linda was 39 years old, an immigrant who had worked and saved for 15 years to open a small wellness spa. She refused the settlement. Instead, she undertook the laborious, expensive, and exhausting task that most victims simply cannot manage. She conducted research. She located the other victims. She retained a private investigator, and she assembled evidence that directly contradicted every theatrical claim Brenda had constructed. When Linda's investigator produced unedited footage of Brenda moving easily through a store, carrying groceries, pushing a shopping cart, and playing with her dog, the narrative of physical incapacity collapsed entirely. When documentary records revealed coordinated review campaigns, cascading complaint filings, and bank records suggesting an organized flow of settlement proceeds, the civil case demanded a considerably wider response. I do not pursue spectacle. I require proof. But proof arrived, and it accumulated steadily, building against a foundation of lies that could not sustain the weight. In court, I asked direct questions because soft questioning allows a practiced predator to read the room and adjust their answers accordingly. When I asked how many lawsuits she had filed, the response could not be permitted to remain vague. 47. When a scrolling timeline appeared on the screen displaying business names, filing dates, and settlement amounts, the architecture of the scheme became visible not only to the proprietors who had lived through it, but to the public watching in real time. When she rose from her mobility scooter, directly contradicting sworn medical affidavits submitted across dozens of filings, that single movement became a critical piece of documentary evidence that no subsequent explanation could neutralize. I explained to the courtroom the core of the matter. The Americans with Disabilities Act and equivalent state statutes exist to protect real people from genuine harm. They are not a licensing mechanism for extortion. When a plaintiff deploys disability claims as an instrument for extracting money through manufactured confrontations and coordinated attacks on a business's reputation, they have crossed from civil grievance into organized criminal conduct. Civil law provides remedies for injury. Criminal law addresses schemes designed to generate systematic profit through fraud. The law makes this distinction clearly, and so do I. I laid out for the courtroom what she had done in precise terms. She selected victims based on their vulnerability: immigrant ownership, thin profit margins, reputational exposure to sudden negative review campaigns. She applied coordinated pressure through hidden camera performances, carefully edited footage designed to tell a specific story, and waves of fabricated reviews engineered to appear organic. She assembled a network around her operation: paid witnesses, complicit physicians willing to provide false medical documentation, an attorney who produced complaints designed to terrify, and a digital marketplace instructing others in how to repeat the method. I have observed considerable misconduct from this bench across many years. This was organized, repeatable, and monetized at scale. When I referred the matter to federal authorities, I did so because the pattern strongly indicated interstate wire fraud, tax violations, and organized extortion. Referrals of this kind are not made casually. Federal investigative resources are not unlimited. Prosecutorial decisions carry serious weight. But when a documentary trail reveals repetitive filings across jurisdictions, traceable financial flows, fabricated documentation, and an active online instructional operation teaching replication, that is precisely the profile of case that federal investigators should pursue. And they did. Subpoenas followed, bank records were examined, the components of the larger picture fit together with an exactness that fabricated evidence cannot produce. What affected me personally was not the theatrical insult, though that conduct will never be tolerated in my courtroom. It was the human accounting. Small business owners had been financially ruined. Families had spent accumulated savings fighting manufactured litigation. Employees had lost positions. Marriages had deteriorated under the pressure, all of it so that one person could transform grievance into a revenue stream. The law was constructed to protect the vulnerable. She had turned it into a weapon, aimed directly at them. That I will not permit. The public response was immediate and intense, because the television moment gave visible form to something many people had felt without being able to name: outrage at the deliberate corruption of protections designed for the genuinely disadvantaged. But the legal result was not produced by public reaction. It required the careful assembly of admissible evidence, unedited surveillance footage with a verified and documented chain of custody, independent medical evaluations conducted by physicians carrying no conflict of interest, bank transfer records and settlement documentation, archival captures of online coaching materials, and the coordinated review campaigns. When the evidentiary discipline is rigorous and the record is properly constructed, public attention can accelerate accountability. It cannot substitute for it. At the conclusion of the hearing, I entered judgment. Ms. Cho was awarded reimbursement of legal fees in the amount of $22,000 and punitive damages of $50,000 for malicious prosecution and fraud. The lawsuit was dismissed with prejudice. The same claim cannot be refiled. More significantly, I transmitted the full exhibit record to the appropriate criminal investigators and requested expedited review because the documentary evidence supported charges that extended well beyond the civil proceeding before me. The bench does not function as prosecutor, but the bench can construct a record that prosecutors are able to follow. There is a lesson embedded in this case about how vulnerability is architected by those who intend to exploit it. Predators depend on isolation. Schemes that rely on victims who never compare notes, who are afraid of further exposure, or who simply cannot sustain a prolonged legal defense spread quickly and efficiently. That is the reason community, documentation, and access to legal aid carry practical importance beyond the obvious. Linda was able to mount a defense because she located others and refused to stop. Most people in her position cannot reach that outcome alone. The systemic response must incorporate better early detection mechanisms, docket analytics capable of flagging repeat plaintiffs, cross-jurisdictional alert systems, community legal clinics with the resources to help business owners document incidents and respond quickly. These are practical reforms, not aspirational language. Let me speak plainly about remedies and structural improvements, because feeling outraged does not close the holes that policy needs to address. Judges carry inherent authority to impose pre-filing restrictions on vexatious litigants. When a party files serial meritless claims, courts can require them to obtain advance authorization before initiating new suits. That gatekeeping mechanism is straightforward and effective. It prevents endless repetition and creates an opportunity for clerks to identify patterns before they compound. Sanctions are not purely punitive instruments. They function as deterrents. Courts should impose monetary penalties, shift fee responsibility, and where the situation warrants it, require bond or security before further filings to prevent predatory claimants from continuing to drain communities through coercive litigation. Technology carries responsibility in this space as well. Platforms that host reviews and public complaint forums must develop rapid detection tools for coordinated manipulation. When dozens of negative reviews appear from newly created accounts, or when the language of multiple reviews follows an identical template, platforms should preserve the associated metadata, suspend the suspect accounts, and cooperate with verified legal processes. Those measures protect genuine consumer trust and reduce the operational tools available to people running schemes like this one. The market for false medical assessments deserves direct attention. This case involved physicians who signed off on reports in exchange for payment. That constitutes professional misconduct and potential criminal facilitation. Licensing boards must act without delay when credible evidence of fabricated medical opinions surfaces. When physicians provide false documentation to support financial extraction, they compromise public confidence in disability protections and in the medical profession itself. Regulatory bodies must treat that as a serious breach and coordinate their response with investigative authorities. A word to small business owners who may be watching. Full protection is difficult and expensive to achieve, but the risk can be meaningfully reduced. Maintain time-stamped records of appointments and interactions. Store unedited footage in off-site backup. Keep correspondence organized and retrievable. Establish a relationship with a legal contact who can be reached quickly for consultation. Build connections within your business community so that when a complaint appears, other proprietors can be alerted and compared notes. Insurance provides some cushion, but rapid documentation and community outreach are more immediately valuable. Isolation is a vulnerability that can be exploited. Reducing it reduces the available attack surface. To judges and court administrators, vigilance is essential. Clerks should receive training to identify warning signs, repeat plaintiffs, complaint text that is identical across filings, coordinated spikes in negative review activity appearing at the same time a lawsuit is filed. When sufficient indicators are present, judges can consolidate related cases, freeze settlement proceeds pending review, and notify law enforcement. These procedural tools preserve access to justice for legitimate claimants while denying predators the anonymity and forward momentum they depend upon. The human damage in this case deserves one final clear statement. The economic harm to Ms. Cho was immediate and concrete. Lost revenue, canceled contracts, clients who no longer trusted her business after the manufactured review campaign. The emotional toll ran deeper: panic, sleepless nights, shame she had not earned and did not deserve. Monetary remedies cannot fully repair that damage, but they are legally necessary and morally required. The restitution orders in this case were designed both to mark the wrong and to return something tangible to the injured. The attorney who profited from this operation also faces exposure. Counsel who facilitates systematic financial extraction through knowing participation in fraud face bar discipline, contempt proceedings, and criminal charges. The bar must enforce ethical standards without exception. Lawyers are the gatekeepers of legal process, and when they abandon that function for a fee, they damage the system that every client and every citizen depends upon. That is not a position open to negotiation. I have been asked on more than one occasion why a television judge would engage in this kind of public accounting. The answer does not require elaboration. Exposure is sometimes a component of accountability. Television provides no special authority, but it delivers transparency at significant scale. When evidence is displayed clearly and responsibly, victims locate each other, witnesses come forward, and investigators receive information they might never otherwise encounter. That does not mean every media moment should be converted into a trial. It means that public scrutiny, applied responsibly and grounded in a proper evidentiary record, is a legitimate instrument of accountability. To the public, do not allow cynicism to overwhelm the willingness to act honestly within the systems that exist. Those systems improve when people use them in good faith. When they are weaponized, reform follows. Both sides of that dynamic have been visible in my courtroom. On this day, the outcome moved toward restoration. To Brenda Marshall, a courtroom is not a stage on which victimhood is rehearsed for financial return. It is a place governed by law, and the law, when it is properly applied, removes the illusions that predatory schemes depend upon. The belief that compassion and anonymity can be indefinitely monetized does not survive contact with a documented evidentiary record. The sentence and the restitution entered in this matter reflect both the legal harm and the human cost of what was done. To Linda Cho and to the others who stood alongside her, the courage demonstrated by each of you constitutes a public good. You did not act only for yourselves. You acted for every person who could not. The willingness to document, to reach out, and to persist made possible a result that isolation would have made impossible. That kind of civic endurance restores faith in the law in a way that no procedural motion can replicate. One administrative practice I insisted upon bears stating for the record. When courts receive patterns of serial filings from the same plaintiff, clerks should prepare a redacted summary of the pattern and distribute it to neighboring jurisdictions and to relevant regulatory bodies. Predators frequently scatter their filings across counties and districts precisely to conceal the pattern from any single court. Cross-jurisdictional communication accelerates detection and materially assists prosecutors who would otherwise need to reconstruct the full picture from scattered fragments. It requires no legislation. It requires only coordination and the willingness to act on what the record shows. Outrage must be converted into institutional change that persists beyond the moment that produced it. The next time a pattern of this kind emerges, the response should be faster, better coordinated, and more decisive, because communities, courts, platforms, and regulatory bodies will have built the capacity to act together. That is how the vulnerable are protected, and how faith in justice is rebuilt one properly documented case at a time.